My name is Candice Priest. I'm an attorney with New Mexico Legal Aid. Today I'm going to talk a little bit about the basics of adult guardianship law in New Mexico, and I'm also going to talk about alternatives that can be used to avoid guardianship and promote independence. I'm first going to talk a little bit about the work I do with New Mexico Legal Aid. Let's see, let me kind of got my, there we go. So I operate a partnership, a medical legal partnership between New Mexico Legal Aid and Christus St. Vincent's. And what that is a collaboration between a civil legal aid organization and a healthcare system, by which I am a legal aid attorney placed inside the hospital typically, although I have to work remotely right now, to represent and advise patients or their loved ones on health harming legal issues. And in addition to providing direct legal services to patients, I also work with the hospital to try to train their healthcare providers on how to screen for patients who are in need of legal services. So when I talk about health harming legal issues, I'm talking about a concept I think many people know of as social determinants of health. So these are all the social aspects of a person's life that seriously impact their health outcomes outside of the actual health care that they're receiving. And I have a really simple graphic that I think illustrates well the work that I do. So I work with the hospital so that they can identify patients who have health issues and also legal issues. This example, I'll say my patient here has got chronic diabetes. This patient has also got some serious financial issues. So maybe this person has entered in an unfair or illegal consumer loan, or perhaps they're qualified for public health benefits and they've been wrongfully denied. They've also maybe got a family violence issue. Perhaps there's domestic violence occurring inside their home. And to compound things, they've got a housing issue. Perhaps they're being evicted or they're facing foreclosure. You can see from my little stick figure here, this person has no chance of addressing their health issues because they have so many other social issues, some of which have legal remedies that are impacting their ability to help handle their health issues. So what I do as a legal aid attorney is I go into a hospital, I educate the staff on the type of health harming legal issues they should be looking for, and then they refer those patients or their family members to me so I can try to assist with legal remedies. And as Tom said, these are only civil legal remedies. I cannot help with criminal issues. The types of cases I'm usually working on fall into these four categories. They're economic security issues. So right now we're seeing a lot of issues with unemployment. They can have to do with Medicaid or Medicare. I also help with housing issues, so folks who are facing eviction, people who are having a hard time with their voucher, perhaps it's being terminated, or they're living in unhealthy or unsafe housing conditions. I can help with personal safety cases. So these are cases where folks need a domestic or facing domestic violence issues and need a protective order. I also try to address elder abuse and elder exploitation. And the last category of cases I help with are decision-making cases. And this is the area I'm going to spend a lot of time talking about today. So these are cases where the hospital identifies someone who maybe is suffering from diminished capacity, but wants to put some planning documents in place to avoid a future guardianship. Or perhaps no planning documents have been put in place and the person is now incapacitated and incapable of caring for themselves. So a family member would like to seek guardianship to provide for their loved one's well-being. So I'm going to set forth just a few guiding principles and considerations that I want everybody to keep at the forefront of their mind during this conversation. And I forgot to say this, but for sure I will answer anybody's question when I finish talking. I think it might be more helpful if I just kind of go through all of this and then answer everybody's questions at the end. So the guiding principles and considerations I want to set forth, the number one thing I want to be very clear on is that guardianship is always the absolute last resort. It really is a nuclear option. We are asking a district court to take away many of our loved ones' rights. So we only want to do that. In fact, the law is designed so that we only can do that if we have exhausted all the alternatives that may be able to meet our loved ones' needs. And that means that guardianship is really only appropriate if our loved one is no longer able to participate in decision-making in a meaningful way, and there's an imminent need for a decision to be made to protect them. It's also only appropriate if there's no legal authority to make the necessary decision to protect our loved one. So to the extent there are planning documents in place that name a power of attorney or a healthcare agent, those mechanisms should be used as opposed to guardianship, unless the person who's been named agent or financial power of attorney is in some way using that power to abuse, neglect, or exploit our loved one. And the last guiding principle I want to keep on everybody's mind is that when we do think guardianship is the only way we can assist our loved one, we also want to be mindful that we have an obligation to limit that guardianship, both in scope and time, if it's possible. So since I think, since I'm communicating that guardianship is really should be the last resort, I'm going to start this conversation by talking about some alternatives to guardianship. I'm going to talk about these three categories of alternatives. I want to be clear, this is not an exhaustive list. There are, in particular, some financial alternatives, such as trust, that can be very useful. That's not an area of law that New Mexico Legal Aid works in, because we typically are representing very low income folk, but this is, I think, at least a starting point for the alternatives you should be thinking about before you seek guardianship. So this first category is more of a concept as opposed to a really kind of strict legal document. Supported decision-making, many of you may be aware of this concept. In fact, I'm certain that many of you are already participating in this type of support, whether or not you know there's a formal name for it. It's a person-centered, person-driven decision-making model that developed out of a case in Kentucky where a young woman who had significant disability was turning 18. Her parents were seeking guardianship for her. She felt like although she had diminished capacity, she really did have the capability to make some decisions on her own. And so she wanted her parents to support her in making good decisions as opposed to take away her rights to make her own decisions. So the concept here is that we work with our loved one who we think may possibly be in need of a guardian to try to make sure that they understand their options. We walk through the factors of any decision. We offer them guidance. Maybe they're making a housing decision, so we try to help guide them towards a safe housing decision. The level of support here really depends on the level of capacity a person has. And I think many people use this as an informal methodology, although there are some jurisdictions where formal written supported decision-making agreements are being acknowledged. Whether or not you want to enter into a formal written agreement to try to kind of outline the parameters around which you're going to help your loved one, I think this is a starting point. When you think your loved one may be needing some support in making decisions, this is the first kind of stop on the train to try to help them before seeking guardianship. There are, of course, also some more formal alternatives that should be considered. So when we talk about guardianship in a few minutes, you'll notice I talk a lot about financial decisions and healthcare decisions, because those are two big categories, really kind of the main categories that a guardian makes decisions for another person regarding. And so one way to avoid guardianship is to have your loved one consider signing a financial power of attorney. Many of you may know that this is a legal document that's outlined in the statute that allows you to designate another person to make financial decisions on your behalf. The document can either outline very specific transactions that are allowed to be made, or it can give someone that you trust general authority to handle matters. It can be made immediately effective, meaning that the person you're naming as your agent can immediately start making decisions for you, or it can spring into effect only after a medical professional assesses you to be incapacitated. I typically advise folks to have a springing power of attorney because it allows you to retain your autonomy to the extent you're capable of making your financial decisions. And to the extent you suffer maybe a brief period of incapacitation, perhaps due to a mental health crisis, your loved one can step in, make decisions for your finances, and then step out of the picture, and you can regain control of your finances following that crisis. To be legally effective, the person who signed this document has to have the capacity to understand what they're signing. They need to fully understand they're signing a legal document that's designating another person to make financial decisions on their behalf. And the person who's named agent is a fiduciary, which means they have an obligation under the law to make financial decisions in the best interest of the person that has designated them as attorney in fact, is a term you sometimes hear. And in New Mexico, it's important to know a power of attorney must be notarized to be legally effective. There are a couple other financial decision-making tools that I think can be helpful as well. If your loved one is receiving Social Security benefits, you cannot actually use a financial power of attorney to communicate with the Social Security Administration about their benefits. The federal government does not recognize state financial powers of attorney. So rather than producing this document for the Social Security Administration, you have to go through a process to be appointed their representative payee. This may be a really good tool if the person that you are concerned about who might need a guardian is really struggling to make financial decisions, and their only benefits, the only income they have is a Social Security check. To the extent they are willing to go with you and communicate with the Social Security Administration that you need to become the representative payee, you may be able to avoid guardianship if what they really just need is money management of this one source of income. Direct deposit and auto bill pay are another couple of tools that can be helpful. I think pretty much everyone receives their paychecks or their benefits through direct deposit, but to the extent we can support our loved ones by setting up an auto pay system so that their utility bills, their rent, their mortgage are paid out of a direct deposit account that has money directly deposited into it, we might be able to help them avoid a temporary guardianship if they experience a brief period of incapacitation due to an emergency, or maybe they're being hospitalized. To the extent we know their bills are being paid, we don't need to rush out into court and ask for a guardianship to help them. An authorization on a bank account is another tool that can be used. I would say it's the least desirable tool. Some of you may hold joint bank accounts with others, or you may be authorized on other people's bank accounts. To the extent they suffer a period of incapacitation and you think you need to step in and make financial decisions for them, you can do that when you are a joint bank account holder or authorized on a bank account. I don't recommend this because I do think it creates a bigger opportunity for exploitation, but it is a methodology some people prefer. So the next big category of decisions that guardians make regard healthcare decisions. And there are some tools that we can put in place to avoid needing a guardian to make healthcare decisions. And the first is a statutory advanced healthcare directive form. So this is very similar to financial power of attorney. It addresses healthcare decisions. It allows us to name an agent, a person we would want to make decisions for us if we were incapable of making our own decisions. It doesn't need to be notarized, so it's a little easier to fill out, especially right now during COVID. It allows you even to decide, what specific healthcare decisions you want made. It's memorialized in writing and can be scanned into your healthcare provider's record, which I think is a very powerful tool to allow your voice to be heard or your loved one's voice to be heard, even at a period of time when they may not be able to communicate their wishes. It only addresses physical healthcare decisions. A MOST form is a very similar form. Some of you may have seen it in your healthcare provider's office. You sometimes see it if you're hospitalized. Sometimes nurses bring it to you and ask if you want to fill it out. It serves the exact same purpose as an advanced healthcare directive, allowing you to designate who you want to make decisions and what exact decisions you want made under certain circumstances if you're ever incapacitated. The difference is that it's signed by a healthcare provider. This can be particularly useful if you've got someone who's maybe got a recent dementia diagnosis and they do have periods of lucidity when they would be capable of understanding what they were signing, and maybe you want to confirm that with a medical professional who's trained in assessing capacity. So like the financial power of attorney, both the MOST form and the statutory advanced healthcare directive form, sometimes people call these living wills, they require that a person have the capacity to understand that they are signing a document that is authorizing another person to make decisions for them about healthcare in the future. So many people don't have these documents in place. I wish everybody did, but thankfully New Mexico has a default statute that can come into play, at least to allow you to make physical healthcare decisions for your loved one to the extent that is necessary and they're incapacitated at some point. The statute outlines a list of people in order of priority that can step in as surrogate decision maker if someone they love is in the, typically this happens when someone's in the hospital and two healthcare professionals assess the person to be incapacitated. The surrogate decision maker can make physical healthcare decisions consenting to certain treatments or certain procedures, and also consenting to placement or discharge from a acute care setting into a rehab setting. You often see this, like I said, in a hospital where maybe your loved one's been in a car accident or has some type of emergency, maybe they've had a stroke and they're currently hospitalized. What I think is important to think about with this statute is that it gives you an opportunity to step in and make decisions for your loved one without having to start a very invasive, expensive guardianship proceeding if it looks like there's a good chance your loved one is going to regain capacity and they are only needing physical healthcare decisions to be made for them. This last decision-making tool I'll talk about, I'm going to spend a little bit more time on because I think this audience may be particularly interested in it. I have not seen it in practice very often, but New Mexico does have a statute that allows someone to fill out an advanced healthcare directive for mental health treatment in particular. And that allows your loved one or yourself to direct your mental health care treatment so that if you experience a decompensation, some type of mental health care crisis, and you're incapable of making informed decisions about your mental health care treatment, this form empowers you to tell folks, to memorialize in writing what it is that you want to happen if an event like this occurs. And I have a bunch of slides you'll see that have a lot of information on them. Like this is an excerpt from the statute. I'm certainly not going to read everything here. I provided it in case people want to look at these slides later on, and I want them to have a resource. What I really like about this form is it is just so expansive. It allows somebody to pick out which doctors they'd want to be involved in their treatment, which doctors they do not want to be involved in their treatment if perhaps they've had a bad experience in the past with certain physicians. It allows them to authorize or to consent to medication. Perhaps they know that they've had an event similar to the one that they expect will happen again or could possibly happen again. And there's certain medication that was very effective for them, or maybe there was certain medication that was very ineffective for them, and they don't want to, they would like people to know that even when they're not able to give informed consent, they don't want that medication. It also lets folks prioritize the type of care, the type of methodologies that might be helpful for them, and actually even rank them or specify them in writing if they're very particular types of approaches that might be helpful to the person. And then it, of course, like the other power of attorney documents or advanced healthcare documents, it allows you to appoint a particular person to make decisions for you as well. So with that kind of a background in alternatives, if we really have tried every alternative possible to try to avoid guardianship, but we believe our loved one is incapacitated and truly incapable of making their own decisions, there are two types of guardianship that can be sought in New Mexico. So I'm going to talk about both of them. The first I'm going to talk about is treatment guardianship, something I think many of you may already be aware of. It's a very particular type of guardianship in New Mexico that allows a person to be the court to appoint a person to consent to mental health care treatment for a person that is incapable of giving informed consent. And the other type of guardianship is often referred to as plenary guardianship. The word plenary is not in the statutes, become, I think, part of the guardianship practice in the state. This is what I think a lot of people think of as kind of traditional guardianship, the type of guardianship where a court appoints a person to make a wide range of decisions, including medical decisions, residential placement, and financial decisions, all to provide for someone's well-being. I'm not going to talk a lot about conservatorship today. I'm just going to say that conservatorship is essentially kind of the financial side of guardianship. Guardians can make financial decisions, and it's appropriate for guardians to make financial decisions if somebody has a limited number of assets or a small amount of income. Conservatorship is appropriate if somebody is in need, if their assets are in need of protection and there are significant assets. There are robust bonding and reporting requirements that apply to conservatorship that are different from guardianship. Since New Mexico Legal Aid typically works with low-income clients, we don't do a lot with conservatorship, but just know that that is something that should be considered if the person you believe is in need of protection has significant assets. When we talk about plenary guardianship, some people are appointed what is called a plenary guardian, which means a guardian who can essentially make almost every decision for this person's well-being. It's important when we're considering asking the court to become someone's plenary guardian or to have a plenary guardian appointed, that we seriously consider whether the guardianship can be limited. So a limited guardianship is a type of guardianship where the scope of the guardian's authority is limited, maybe to specific decisions. Perhaps the person that we think needs protection is capable of making a certain category decision and not others. So the guardianship should be limited so that the guardian's authority only covers the area of decisions that they seem incapable of making. And temporary guardianship limits the scope of a guardian's authority to a specific amount of time, typically 60 days in an emergency situation. I think it's most appropriate when our loved one is in the hospital and big decisions need to be made about their health care and about their finances very quickly. There's a way to petition to the court to ask the temporary guardian be appointed if the person is in an imminent danger of harm. So I'll first talk a little bit more about treatment guardianship. Treatment guardianship is only appropriate in a very limited instance, which is when a person is in need of mental health care treatment and they are incapable of giving informed consent to mental health care treatment. So where this typically plays out is when there's a mental health professional involved. Often the mental health professional actually even starts the process of seeking treatment guardianship. But I would say cannot think of an example when there wouldn't already be a mental health professional involved who is telling you that your loved one is in need of mental health care treatment, and based on their clinical professional judgment, your loved one is incapable of giving informed consent for that treatment. The process for treatment guardianship is a little different than it is for traditional guardianship. I think I've I think a lot of times treatment guardianship comes up when somebody is already institutionalized or maybe in a psychiatric hold, and either the treating healthcare professional or the facility actually initiates the process. But it's also possible for another interested party, someone's loved one, to initiate the process. Regardless of who starts the process, it starts by someone filing a petition, a legal document that has very specific information outlined in statute with the district court asking for a treatment guardian to be appointed. The standard that has to be proven in order for a treatment guardian to be appointed is that there is clear and convincing evidence that a person is not capable of giving informed consent to mental health care treatment. The person who files this petition is called a petitioner, and that person, the petitioner, or maybe their attorney, if they've got an attorney, they're responsible for making sure the petition is personally served on the person for whom we're seeking a guardian, who's called a respondent. And that is because our legal system is designed so that if we seek guardianship for our loved one, they are given many opportunities to contest that guardianship if they disagree with it and would like to prove to the court they do not need a guardian. The respondent in a treatment guardianship process has to be represented by an attorney, and the court can appoint an attorney. In all the cases I've had for treatment guardianship, the court has appointed an attorney for the respondent. A hearing has to be set within 3 days of the filing of the petition. I think there are some facilities and some healthcare facilities in this state where actually there are district judges who come in on a regular basis, regular intervals to have these hearings, but the statute is designed so that if you ask for a hearing, it should be set in 3 days, which is a very quick turnaround in the legal system, and it's not a turnaround that is typically available for plenary guardianship. I think the idea is here, when we're seeking treatment guardianship, it's because there's a mental health crisis that needs to be addressed very quickly. And so we're asking the court to give someone permission to address that emergency as soon as possible. There has to be a hearing on the matter, and at the hearing, the treating healthcare professional must testify about the respondent's inability to make informed decisions about their mental health care treatment and has to provide information about their proposed course of treatment. And the treatment guardianship cannot exceed 1 year. In my practice, I have not seen treatment guardianships that are set forth for an entire year. What I typically see very thoughtful judges who ask the treating healthcare professional, what is the amount of time we would expect to see a result based on the course of treatment you're proposing? And then we typically have a follow-up status hearing in that period of time to see if the person has regained capacity and no longer needs a treatment guardian. So I won't read much of the statute to you, but I think one really important statute to read if you're thinking about seeking treatment guardianship for your loved one is what the definition of having capacity to make mental health care treatment decisions is in New Mexico. Because I sometimes had folks come to me and say, my loved one makes really bad decisions and I want to help them, so I want to be their guardian. And bad decisions may be evidence that someone needs a guardian, but they're not necessarily, that's not really the standard. Bad decisions aren't the legal standard. What the standard is for knowing whether or not a person has capacity to make mental health care treatments is outlined in statute. And a person in New Mexico, a person has capacity to make mental health treatment decisions when the person has the ability to understand and appreciate the nature and consequences of proposed mental health treatment, including significant benefits and risk and alternatives to the proposed mental health treatment, and to make and communicate an informed mental health treatment decision. And I think this is just a really important statute to look back at and read if you're considering seeking a treatment guardian for your loved one. It is clearly a tool that it does need to be used sometimes, but we need to be sure it's being used appropriately because someone truly doesn't have the capacity to give make informed decisions, not because they are denying something that we would like them to, some treatment that we would like them to have. And this is why I think it's so important that treatment guardianship to only be pursued in conjunction with the healthcare professional who really has the clinical training to assess whether or not someone has capacity to make their own mental health care treatment decisions. I certainly won't go over all of this. I just want to make sure you guys have the statute that outlines what is required to be in a petition if you ask for treatment guardian, to be appointed treatment guardian. So the next category of guardianship I'll talk about, I'm just going to call it guardianship. It's what people think of, I think, when they ask me about guardianship. And it's the type of guardianship that allows the court to appoint someone to make a large variety of decisions for somebody in order to promote and protect their well-being. And it should only be used to the extent it is necessary because of functional, mental, and physical limitations that make someone incapable of caring for themselves. It is a similar process, but a little bit different, and certainly I think a much longer process, and I think could be a much more expensive process here in New Mexico. If you think that your loved one may need a guardian because they maybe are not able to care for themselves or make financial decisions, you need to file a petition with the district court, either with you or an attorney. And I think there's some healthcare facilities that have done this when folks have no loved ones, but typically it's someone who has an interest in the welfare of the person, so it makes sense for it to be their loved one. That petition has to have really particular information that's outlined in statute, explaining why you are seeking this court proceeding to adjudicate whether or not your loved one has capacity to make their own decisions. Important to note is that a whole bunch of parties have to get notified if you start a proceeding like this. Folks who would have an interest in the person who you are saying needs a guardian's well-being. And it is your job as petitioner, or if you have an attorney, their job to personally serve all these documents on the alleged incapacitated person. And the reason we have this notice requirement and why it's a personal service notice requirement is we want to be certain that the person who we are telling the district court judge that they need a guardian is being given ample opportunity to contest the proceeding if they believe it is inappropriate and unnecessary. One thing I like to make really clear to folks is if you petition for guardianship in New Mexico, really in any jurisdiction, you don't become guardian. You don't get to tell the court, I think my loved one needs a guardian and I am going to be the guardian. You can tell the court, I think my loved one needs a guardian. Here are all the facts that back that up. And here's why I think I would be the best guardian. That's contained in the petition. But there are a slew of professionals, 3 other professionals, in fact, who have a big driving force in how the proceeding goes. And so I think of the petitioner as someone who is kind of raising a flag for the court, telling the court, we're really concerned about this person. Either I want to be guardian or I think another person might be an appropriate guardian, but I'm asking the court to initiate an expansive investigation to decide whether or not this person needs a guardian, and if they do, who that guardian will be. One of those professionals is the qualified healthcare professional. So this is a healthcare provider that's performed a formal capacity assessment on your loved one and filled out a specific report outlining what level of capacity they believe that your loved one has. This report gets filed with the court, and this person gets appointed as the qualified healthcare professional for this particular case. Two other professionals who serve a big role in these proceedings are the guardian ad litem and the court visitor. The guardian ad litem is typically an attorney who serves as a representative of the person who needs protection. So they're kind of like the lawyer for the person, your loved one, who you say you're telling the court needs a guardian. That guardian ad litem has a couple of jobs. They're going to call up the person for whom we're seeking a guardian, tell them what's happening, try to see if they're understanding that this guardianship proceeding is happening, ask them how they feel about it. They'll report the alleged incapacitated person's position back to the court. They'll also do a large amount of investigation. They'll interview any relevant parties they think may have pertinent information that would speak to this person's capacity. They'll review medical records, and then eventually they will write a report that has recommendations for the court about what should be done in this case. That report is very important. I think judges really rely on that report. The other person who writes a report is the court visitor. And that is a person who kind of serves a similar role to the guardian ad litem because they certainly have the same kind of investigation role, but they're a little bit different in that they are really an unbiased arm of the court. It's generally a social worker who's appointed to investigate the matter. They do a lot of the same interviews and reviewing of medical records as the guardian ad litem, but unlike the guardian ad litem, their role is not to represent the alleged incapacitated person's position on the proceedings as much as it is to give an unbiased recommendation to the court on whether or not a guardian should be appointed, whether or not the guardianship should be limited, and who would be an appropriate guardian in the court visitor's opinion. After all of this paperwork is served and reviewed by the court, there has to be a hearing on plenary guardianship before guardianship can be granted. As I said, if there's an emergency situation where a loved one is in imminent danger, or maybe their assets are in imminent danger, you can seek temporary guardianship, and that can actually happen on an ex parte basis, meaning you write a petition asking the court to appoint you or someone else's guardian without a hearing for a short period of time to address an emergency. But before anyone in New Mexico is appointed a permanent guardian, there must be a hearing on the matter to give the person an opportunity to contest the proceedings. So just a little bit of a review, because I know that it's quite a lot of information. When we think about guardianship, we've got a group of parties involved, and we've got some documents involved. This list of parties is the number one person is the person for whom you're seeking protection. You're the alleged incapacitated person. The petitioner and the petitioner's attorney are the folks who are initiating this process. The qualified healthcare professional is the healthcare professional who provides a written report for the judge to review and rely on in terms of a healthcare clinical professional opinion on capacity. The guardian ad litem is the attorney that is appointed to represent the alleged incapacitated person. The court visitor is a social worker who does an investigation similar to the guardian ad litem, and the district court judge is ultimately who makes the decision as to whether or not your loved one will have a guardian and who that guardian will be. And just to be clear, I alluded to this earlier, you may not become the guardian for your loved one. In fact, it may be a third-party guardian that's a professional guardian. And I just think that's very important for people to know before they start a process like this, because this process becomes, it's like a train that gets going, and you can have somewhat of a say in it and certainly present your position to the judge, but ultimately this district court judge is going to decide what happens to your loved one, at least who's going to make decisions for your loved one after you petition to start this process. So the documents that are involved, there's a petition, like I said, that initiates the process. There's a qualified healthcare professional report. It's a standardized report that's provided that outlines the clinical opinion of the healthcare provider about this person's capacity. There's a request for hearing you have to file that actually asks for to have a hearing, a notice of hearing that has is very specific language giving notice to your loved one about the proceedings. It has to be, all of these documents actually have to be personally served on the person for whom you're seeking a guardian. The guardian ad litem report, the court visitor report, those two documents I think are the most important in a guardianship proceeding because they are the result of many, many hours of investigation. And I think courts really rely on them to understand the situation that this person that may be in need of protection has been living in recent times. If the district court judge believes there is clear and convincing evidence that a person needs a guardian, they sign an order appointing guardian. Then the person named guardian signs an acceptance. It gets notarized and filed with the district court clerk. The district court clerk then signs letters of guardianship, and the combination of the letters of guardianship along with the order appointing guardian are the two documents that a guardian uses to provide proof they have legal authority to make decisions for another person. And also on here, I'm mentioning guardianship reports because there are robust guardianship reporting requirements that apply if you ever become a guardian for someone that you care about. Again, I'm not going to try not to spend too much time reading statutes to you, but I think understanding the definition of capacity is really important because like I talked about in treatment guardianship, I sometimes have people come to me and say, my loved one makes really bad decisions. I think I should be their guardian. And I sometimes ask them to read this closely to see what types of quote unquote bad decisions might really be evidence for guardianships. So an incapacitated person in New Mexico is any person who demonstrates over time either partial or complete functional impairment by reason of mental illness, mental deficiency, physical illness or disability, chronic use of drugs, chronic intoxication or other. And to the extent they are unable to manage their personal affairs or unable to manage their financial affairs. And the idea that you can't manage your personal affairs, there needs to be some evidence that you're not able to meet your medical needs, your nutrition needs, your clothing, your shelter needs, that you're not able to meet your hygiene needs and to create a safe living environment for yourself. And when it comes to finances, it requires truly gross mismanagement of finances. I think so if somebody forgot a couple of bills, that does not mean they need a guardian. I mean, it may mean that they are developing dementia and need some assistance and may ultimately need a guardian if planning documents aren't put in place. But it really needs to be gross mismanagement of resources, financial resources, before we seek guardianship on that basis. This again is just a slide for you guys if anybody would like to try to petition on a pro se basis to be their loved one's guardian. I just wanted to be sure you guys had the statutes you need to know what's included in a petition. This statute outlines who can be a guardian, and I just want to point out there's a list of priorities in terms of who a judge is going to consider as the person to be guardian. And to the extent, for example, you're someone's spouse, you're very high up on that list. But it does not necessarily mean you will by default become guardian. There's a process the judge will go through to decide whether or not you're the appropriate guardian, regardless of where you fall in this priority in the statute. If you become your loved one's guardian, it's really important to know that you have an obligation under the law to try to talk to the person for whom you're trying to, the protected person for whom you're trying to make decisions, and try to figure out what their desires are and try to make decisions consistent with their wishes, as long as if you can do so consistent with their protected person's well-being. Guardians aren't required to use their own personal funds to provide for the protected person, and they aren't personally liable for the actions of the protected person, but they are obligated to manage their financial means to their maximum benefit. And that can mean seeking public benefits for the protected person in order to make sure they have the maximum amount of resources, and also to try to find a safe housing environment for the person. There are reporting forms that are required. They're approved by the New Mexico Supreme Court. They've got to be filled out. They have very specific information that a guardian's got to report to the court, first within 90 days of the initial appointment as guardian, and then every year within 30 days of the anniversary of guardianship. They address the protected person's health, their living arrangements, their finances. They're quite expansive, and they can feel very, very invasive. If you seek temporary emergency guardianship, I've seen many judges ask for interim reports that involve the type of information that's described in the annual reports. And the reason I bring this up is that it is one of the reasons I try so hard to look for alternatives to guardianship if they are possible, because to the extent you can get a healthcare directive in order and a financial power of attorney in order and avoid guardianship, you avoid having some really personal information put on court record. They are sequestered cases. They're not publicly available to everyone, but they are part of the New Mexico court system's records. So there are financial penalties that apply if you don't fill out these reporting forms, or if they aren't, if either they're missed deadlines or you don't provide adequate information. I'm glad to say that oversight is certainly increasing in this area to make sure that guardians are indeed actually providing for the well-being of the people, of the persons for whom they are charged with protecting. In New Mexico, like any other jurisdiction, you should theoretically be able to bring any court case as a pro se litigant. But there are some unique challenges, I think, to bringing petitioning for guardianship in New Mexico on a pro se basis. And one is that the petition and other court documents I talked about, which are called pleadings, they require very specific information, and they require certain formatting. And we don't have pro se forms for guardianship readily available here in New Mexico. So it could be quite a challenge for someone who maybe is not trained in the law to actually produce the required documents and meet the statutory requirements for providing notice to their loved one in a proceeding like this. I also find this is not limited to New Mexico. This is everywhere I have practiced. Physicians are often really uncomfortable filling out the qualified healthcare professional report. They may feel comfortable telling you they think your loved one is really in need of some serious support, and they may allude to the fact they need a guardian, but I find many physicians are uncomfortable being appointed as the qualified healthcare professional for a guardianship case. Also in New Mexico, in other jurisdictions, if you petition for guardianship, the court system actually has paid court visitors and guardian ad litems who are appointed to cases randomly. But in New Mexico, the practice is, the expectation is that petitioners will provide the name of a court visitor and guardian ad litem who are willing to be assigned to the case that they are initiating. And this can be a practical issue because there's not some type of like master court visitor or guardian ad litem list. And so finding a professional who's qualified to serve these roles, willing to serve these roles, and then figuring out how they're going to get paid can be an issue, because they are typically paid out of the alleged incapacitated person's estate following the guardianship proceeding. But to the extent the proceeding doesn't lead to a guardian, or maybe the person doesn't have any assets, if you're a petitioner, may be expected to pay those professionals, and their services can be quite expensive, especially if the case is very complicated and takes many, many hours to investigate. And this last slide here is just some resources for folks out there. If you're thinking maybe your loved one might need a guardian, you can certainly go to the New Mexico court website to get some information about guardianship. The Office of Guardianship is a statewide publicly funded agency that provides one-time legal services based on income eligibility to help families get a court-appointed guardian for their loved ones. I know there's a very long waiting list, but if you go to their website, you can apply for services. I think they're also, based on regulations, supposed to have a sliding fee scale to help folks who maybe can't afford a private attorney, which can be very, very expensive in guardianship cases. But I don't have a lot of information about whether or not a sliding fee scale has ever really been initiated, or what it looks like with the Office of Guardianship. The Office of Guardianship also has trained treatment guardians. So to the extent you you know that your loved one needs a treatment guardian, perhaps their treating physician has told you this, but you can't be that person. It's too emotionally challenging to make these mental health care treatment decisions for your loved one. The Office of Guardianship can be a resource to get a trained treatment guardian appointed for your loved one. And they also handle complaints about guardians, particularly about corporate guardians, but I think also about family guardians. I think they have a great resource that I'd consider before you call up a lawyer and seek guardianship. If you think your loved one needs guardian, you might want to be their guardian. I'd highly recommend going to their website to review their educational material. They have a couple of videos and a handbook, all of which are required to certify to a district court that you've reviewed prior to becoming a guardian. So looking at that before you even initiate the process, I think is a good idea to really understand what guardianship entails and decide whether or not you are willing or able to take on that role. And lastly, the Office of Guardianship has a list of private attorneys that practice in this area. If that list is not helpful, there's the State Bar Referral Program that allows you to call these two numbers and one of these two numbers and pay a referral fee to be connected with a lawyer that specializes in guardianship. And they can give you a short kind of, I think it's maybe a 30-minute consultation, and to the extent you want to hire them for representation to seek guardianship, their fees are negotiated separately. I think the Office of Guardianship, as far as I'm aware, is the only agency in New Mexico that provides free legal services to help anyone seek guardianship for their loved one. The only other one is New Mexico Legal Aid, and I am actually the only attorney that does that, and I do that only through our partnership with Christus St. Vincent. So to the extent you have a loved one who's part of the Christus St. Vincent's health system receiving care there, and you're seeking my assistance, you may ask for a referral to see if I can assist you as well. So with all of that, I'm going to stop sharing my screen. I don't have a clock here, so I hope I didn't talk too long. I think we're going to maybe, I don't know if anyone's here or has any questions.
I think your timing is perfect. Jess, do you want to unspotlight the video? Can you do that so we can get questioners up? Excellent presentation. Thank you very, very much. I think the first thing we'd like to do is throw it open to questions. Betty had one before she has to leave us. Do you want to ask your question, Betty?
You talked about advanced healthcare directive, but I didn't hear anything about medical power of attorney.
Those are the same thing. I don't know why the legal system is designed this way, but the words living will, advanced healthcare directive, medical power of attorney, most form, those are all functioning the same thing.
Okay, that clarifies that. Thanks.
I wish the legal system didn't call them 4 different things. I know that's very confusing.
Thank you. Jess, do we have any questions off Facebook?
Off Facebook. I don't see any on Facebook so far.
Excellent. Do we have anybody in our audience who has a question before we, Cameron?
Thanks, Tom. Question, and thanks, Ms. Priest, so much for the presentation. And my question was, to what extent do 2 other types of legal relationships serve in place? And one, of course, would be marriage. To what extent does a spouse able to make decisions? And then the second would be, is adult adoption ever used? Does that provide any legal benefit in form of guardianship? So thank you.
Absolutely. So for a spouse, yes, there's a lot of spouse can do without having to seek guardianship. To the extent you've got a joint banking account, that allows you to make financial decisions. If your spouse ends up in the hospital, they'll be named undoubtedly surrogate decision maker unless there's some really compelling reason the hospital doesn't think they should be. The problem is that their spouse doesn't by default get to make mental health care treatment decisions. So that's why they might end up having to seek treatment guardianship. But yeah, I find that rarely spouses seek guardianship for their spouse. I find a lot more common that adult children, their parents are seeking guardianship for them, or the reverse, that adults are seeking guardianship for their very senior parents who they don't share bank accounts with or have any planning documents for. And then your question about adult adoption, that's a great question. I don't have a good answer for that. I remember learning about this in law school, but it's something I've not really explored in my practice. So I'm sorry, I can't answer that.
Yeah,
thank you very much. Tina, you had a question.
Thank you. Yes, thank you, Candice. This is an excellent presentation. I'm kind of coming at this from a different perspective. I'm a peer facilitator, so I work with peers. I'm also the parent of young 20-somethings. And as a parent, I can say my goal has been to raise fully independent children that can function alone in society. What we've run into on some of our peers, I don't know if you're aware, mental illness has a high correlation of presenting in young adulthood, late teens, early 20s. And so you have a situation where a young adult was not able to function for a number of years. Guardianship, either guardianship or financial power of attorney or representative payee through Social Security, I'm not sure which, comes into play. Now we're talking late 20s, early 30s. And, the peer has found housing support at this point, is able to function on a budget, has a job, that kind of thing. But they seem to be stuck under this old or, from a 5-year, 10-year-old, either guardianship or power of attorney, I'm not sure which it is, and doesn't seem to know how to progress out of that. They feel that they're capable of more now. Their guardians are expecting more from them than they see. And it seems to me there should be some way to level up and out of that fully dependent relationship.
Absolutely. I'm so glad you asked this question, because there is actually. So to the extent somebody is really functioning a lot on their own and they're not needing a guardian for every decision making, in the exact example you gave, they can petition the court. They can actually just write the judge a letter that's assigned to their case, explaining that they want their case reviewed. If they have a corporate guardian, they can do the same thing to the Office of Guardianship. But I would love if maybe we could talk offline. You can maybe call me. I have been looking for a case like this. I know this has happened, that a young person is assigned a guardian and they are able to start managing their mental health issue and actually don't need a guardian anymore, or at least need to super limit that guardian's authority so that the guardian no longer gets to make all the decisions. And there is a process. Theoretically, they should be able to just write the letter and open the case with the judge. And some judges would be receptive to that. But I would love to work with someone in this situation to collect medical documentation to help them do this, because I think this is a really important area. I think people are always asking me how to get a guardian, but sometimes guardianships need to be undone, and it can be very challenging to do that.
Especially because given the past relationship, it's difficult for a peer to move into full independence when they have a poor relationship with the growing up phase already. And now they're vulnerable. And that's the struggle I'm finding, is that peers are vulnerable and it's difficult to find where the representative voices. I don't know the advocate guardian I'd like them to reach out to in this case, one particular case. And we're not in a situation, NAMI is not actively representing peers, but we are trying to give guidance and resources for them to seek on their own. So yes, thank you. I would love to follow up with.
If one comes to me through this partnership, or maybe if you even just want to maybe call me after this and talk about it, I would be really interested in helping that person. And also, I think the disability rights, disability law center, I always get their name wrong, I'm sorry to say, they probably are also another good resource, because I know that they do this advocacy work as well. Thanks for asking that question.
Thank you. Any other questions? Okay, there are a couple more. You talked about guardianship cases that you've done in Santa Fe. About how many cases of guardianship have you seen go through the Santa Fe court, say in the last year or the period you've been working?
So I've only handled 4, because
Okay.
I'm really of the belief that I've been referred a lot of cases that people think they need guardians in, but I really firmly believe it should only be used in very extreme cases where it's the only option. So what I do if I'm referred to cases, look for other alternatives, and that there only been 4 times when, particularly because of dementia and a couple of really serious mental health crises where that wasn't possible. So only 4.
The next question that came up was, one of the challenges parents of people who end up in Christus or other hospitals for behavioral health crises run into is getting information about what's going on with their adult child, whether it's medical information, whether it's the treatment being provided by the hospital, especially in the emergency department. And I think sometimes they don't get told about the surrogate opportunity that you mentioned, surrogate decision maker. You know, how can such a parent or a friend advocate for their role, and how do they convince the medical individual? I mean, what do they do when they go to the, or in the emergency department, and they just run into a wall? And all these things you've talked about that they're referencing, even having a treatment guardianship, nobody will listen to.
Well, call me, please. First and first, please call me if that happens, because now you've got my phone number and I'd want to help you for sure. If I don't answer, if it's the middle of the night, I think the first thing I'd do is say, I believe if you are already the treatment guardian, to say, I have a right to have this information and I want to talk to, you know, somebody in charge because I have a right to this information. If you maybe aren't treatment guardian, but you know that might be the direction this is heading because there's a crisis, I would say to them, I'd like to talk to somebody about becoming my loved one's surrogate decision maker, because that should at least trigger them getting a case manager involved and escalating it to the team of folks who I think would be able to get an affidavit signed. I think what I get cases a lot of times when folks are already admitted. So once someone is admitted and things have slowed down, they'll start communicating better with the family. The ER, I know, is a challenging place to get information for a lot of reasons. Those are my two pieces of advice. You know, really push and say, I think I have a right to this information and here's why. And then if you're getting nowhere, please do call me.
Excellent. Thank you. I wanted to ask one other question, and this may be a program you're not familiar with, but I see a question, and I'll let that question come up. Mr. Elliott?
No, why don't you do your question and come back to mine?
All right, be glad to. The fire department in Santa Fe has something called Smart 911. Are you familiar with that program?
I'm not.
Basically, it's a database for first responders that the public can put in, and they can create their own account that's only active during an emergency call. But it gives the family, especially families with one or more people with health problems, the opportunity to tell the first responders any key pieces of information they need when they get there. Is there any legal type information like you're describing that would be valuable for first responders to know when they show up on a 911 call for a behavioral health crisis?
Wow, that's a really cool program I hadn't heard of. You know, the only thing that comes to mind are those planning documents. So like the advanced healthcare directives. But I mean, the likelihood that you're going to have those like stamped on your front door seems pretty unlikely, right? You're just going to have them readily available. But those are, I do highly recommend if you fill those out that they get scanned into your medical record, because at least when you get to the hospital, they should pop up immediately when they scan your name into the system. I'm not sure I have a good answer for first responders though, I'm sorry.
Well, and in fact, the system allows you to input documents if you want to.
Oh, wow. Well, then
So
I would highly recommend having scanning in advanced healthcare directives, because to the extent you've outlined, say in the mental health care directive, what are the steps you want taken? Hopefully the first responder will look at it before they walk in the room and see, okay, this person tells me this type of response is helpful for them. It's typically used also for, DNR status with physical healthcare issues.
Excellent. Now the question, Mr. Elliott.
Yeah, no, I just was wondering if you could give us a little clarification. I'm a little confused in terms of the financial arrangements and power of the court to make decisions that result in financial obligations on other people.
So the New Mexico statute, I don't have it pulled up, but if you want to follow up, I can send it to you. There's a New Mexico statute in the Guardianship Code that says specifically that after a person is adjudicated through a guardianship process to be incapacitated and in need of a guardian, all of the professionals who provided services for the guardianship proceeding can be paid out of their estate, which in some ways is logical because it's a very time-consuming process. On the other hand, it does in some ways concern me to think that a court can rule that you're going to pay $8,000 out of your savings to pay for a proceeding maybe you didn't want. But that is how the New Mexico law is designed.
So that would be out of the estate of the person who is pleading with the court, or would that be out of the state of the person who benefits from the decision of the court?
It's from the person who benefits, so the person who gets a guardian. Because the logic, I think, exactly is that you're benefiting, you're incapacitated, you couldn't ask for this help, so you're benefiting by having a court-appointed guardian assigned to you, and that process was expensive and time-consuming, so you're going to pay for it. Although there are many folks, of course, who there's no money for them to pay in the end, and that's why the Office of Guardianship is designed and why New Mexico Legal Aid exists. Although there are some real challenges. I really wish we had a different system where guardian ad litem and court visitors were maybe paid through the court system, because I think this is a huge barrier for even middle income folks who want to help their loved ones. Because it's my understanding a case can cost somewhere between $8,000 and $10,000, which is just outrageous.
So do you have recommendations in that regard?
So what I've done when I started this partnership back in February, I basically just started calling everybody who I could find, who either through our volunteer program or I had met through relationship with the hospital, to see who might serve as volunteer guardian ad litem and court visitors. And in cases where we are sure someone has no resources, I've been able to find a few volunteers. If you want to contact me after this on my phone number or my email, I'm happy to share with you a couple of court visitors and guardian ad litem that I thought did a really good job and were very thorough in these cases. But it's been a real challenge because in my previous jurisdiction I practice in, this idea that we're supposed to go find guardian ad litem and court visitors, I just really surprised when I got to New Mexico, because it's just not a readily available list, which I think it's because petitioning attorneys develop their own relationships with these folks. But I think that's the real problem for pro se litigants.
Excellent. Any other questions? Jess, anything else on Facebook?
No, we have some watchers, but they haven't said anything yet.
Well, we're grateful that they're watching, and that pretty much, let me thank our speaker again. It was an outstanding presentation, full of information. It really moved nicely, and I look forward to a great relationship between your program and NAMI here in Santa Fe. And please reach out to us if you ever find any time or thing that we can do to help you, because I think what you're trying to do is very much similar to what we're trying to do, and helping our community.
Well, thank you so much. I was really grateful to have a chance to talk to y'all, and please don't hesitate to reach out to me. The partnership is designed so that I receive referrals through the hospital, but I am a member of this community and I really want to be a resource to this community. So if there's anything I can help with, don't hesitate to shoot me an email or call my cell phone. Thanks again.
Thank you.
Thank you.